It is important to note that legal guardianship can come to an end when the child reaches the age of 18 years old. Good afternoon. My name is Omolade Animasham, and today I'll be speaking on how to obtain legal guardianship in Nigeria. First, what is legal guardianship? Legal guardianship is the legal arrangement that enables a person to assume a responsibility for the care, custody, and welfare of a child whose parents are incapable of raising him or her. So now that we know the meaning of legal guardianship, who then can apply for the legal guardianship? An application for legal guardianship can be made by the relatives of the child, any person having family ties to the child. It can also be made by the Ministry of Youth and Social Development, where the children or the child is in care home or in an orphanage home. Then the next thing we'll be considering is the rules that govern legal guardianship in Nigeria. Basically, there are several laws that govern legal guardianship. The first is the Child Rights Act. This is the one that governs or protects the interests of children across Nigeria. While we have the Child Rights Law of Lagos State, which deals with protection of children or ward in Lagos State. Having known the rules, the next is to know the courts within which an application for legal guardianship can be held. An application for legal guardianship can be held in two courts, which is the Magistrate Court of any state and the High Court of any state. Next, we'll consider the procedure for commencement of a legal guardianship action in court. So the first thing to do when commencing an action for legal guardianship is to file an originating motion, either at the Magistrate Court or the High Court, depending on the court you wish to use. Then the application, that's the originating motion, must be accompanied or supported by certain processes. The first is a statement of case, and a statement of case encompasses the descriptions of the applicant, the descriptions of the respondent, the relief sought, so the relief sought and the grounds for such relief. Apart from the statement of claim, the originating motion would also be accompanied by an affidavit of fact. The affidavit of fact contains basically the summary of facts as it relates to the application for the legal guardianship. Then we have the statement of arrangement for the child, the statement of truth, and any other necessary documents. So, originating motion must be accompanied by certain documents from the applicant and the child. So one of the documents are the international passport of the applicant, the birth certificate of the applicant, the birth certificate of the child in question, the marriage certificate of the applicant where he or she is married, then the death certificate of either of the parents of the child if they are deceased, then application or consent of guardianship from the applicant, and consent of guardianship from the respondent. At times, it could be accompanied by evidence of the medical certificate of the applicant, contracts of employment of the applicant, and photographs of the applicant's home. So in conclusion, it is important to note that legal guardianship order can come to an end when the child reaches the age of 18. Thank you.